third module of our course on public interest concerns in patent law. This module, we are going to discuss about 4 case studies. The first is a recent judgment of the Delhi High Court. This judgment was pronounced on 21st July 2023 by a bench comprising of Justice Mr. Najmi Wasri and Vikas Mahajan. And this is actually a case relating to the validity of terms in the patent licensing agreement. It's actually a voluntary agreement but still voluntary agreements play a very important role in prevention of patent abuse, and the relationship of competition law with the licensing term is a very crucial matter, and it will also apply to compulsory licensing and prevention of patent abuse, and therefore I am taking this case. These 2 cases are not on pharmaceutical patent law. The first case is between Lm Ericsson versus Competition Commission of India. This case relates to the issue of charging more money from a patent license agreement, even though such patents come in the category of standard essential patent. If it is a standard essential patent, which is very crucial for the smooth functioning of the industry, which involves different stockholders, multiplicity of licensings, and possibility of the subcontractors using your license, and occasionally even a user who just logs on. So, standard essential patent. We'll have to have a separate lecture on that. Okay, therefore that is the Ericsson and the other parties, try to have a patent licensing agreement where licensees complained that, they have been made to pay more. This is on telecommunication standard essential patent. The other case is between Monsanto Holdings Limited versus Competition Commission of India. The date of judgment was given on 13th July 2023 actually. The judgment is just about 10 days old. As a matter of fact, I have only given it a cursory reading and I tried to quickly comprehend myself the facts and the law involved, because I thought this will have a bearing on considering voluntary and compulsory licensing agreements relating to pharma patents. Now, we are also going to discuss in our future lectures the Lipitor case, patent relating to atorvastatin. And we are also going to take another case study, omeprazole. Dr. Reddy's blockbuster drug Omaze, and original inventor was AstraZeneca, and these 2 pharma case studies also we are going to look at. But before I look at that, I thought, I should bring it to your notice a most recent judgment of the Delhi High Court. And this Delhi High Court judgment has been given by a division bench actually. Division bench means 2 judges. The precedentary value of such judgments are slightly higher than single judge's judgment. Now, what is this case involved? Originally, there was a complaint by the Competition Commission. The issue that came up for consideration, which is what the Delhi High Court decided in this case, is competition law, Indian Competition Act and Indian Patents Act. Both are self-contained special legislations. from the point of view of jurisprudence, this is how you should describe both the legislation. Number one, they are self-contained legislations. The statute lays down substantive principle, mechanism of implementation, appellate mechanisms or oversight mechanisms, remedies in case the rights guaranteed under the statute are violated, principles of limitation, like within how much time you have to act, okay? So a lot of other things, everything that is needed to implement the statute has been provided for in the statute itself. This is a self-contained legislation. See, in law, we use these two expressions. Subject to the laws that are in force for the time being. This is how a legal provision will begin. When the legal provision begins with this prefix, subject to the laws that are in force for time being, then the statutory provisions are going to play its role in the overall scheme of other legislations that are available. So if there is going to be a conflict, between some other law and this provision, the court will consider in each case how much of the other law should overrule this law, override rather. That is what it is. And the other expression is, notwithstanding anything contained in any law time being in force. This is the non-obstante clause. That's how the lawyers like to describe this as. This means, even if there is going to be a conflict between some other law and this law will prevail. This is what it is, In some cases, there can be concurrent remedies also, and I am not going into it, but I guess that issue is something which the Delhi High Court should have gone in this case anyway. Now, let me cut the long story short. The first thing is that, number one, it is a self-contained legislation. Number two, it is a special legislation. And mercifully, both these legislations have been passed by the Indian Parliament. If one had been passed by the Tamil Nadu government and the other law by the Union government, then there will be a conflict on grounds of legislative competence, occupied domain, pith and substance, violation of federal features, a lot of other complications come. But mercifully in this case, both the patent law as well as the competition law have been passed by the Union of India. Parliament, Indian Parliament had passed it, and the executive is the government. And the government had constituted specialized agencies like Controller General of Patents, to implement the scheme of the Act. And the law provides elaborate mechanism for oversight, remedies in case the rights which are guaranteed under the statute are violated. Fine, that is one aspect of it. Now here is the other law, competition law. Actually, the history of competition law in our country has been very checkered. It didn't have what I call as a great style from the beginning actually. After all, we have to recognize that we have been having a patent office right from 1911. But we didn't have this MRTP's commission as late as 1970. That is because the Indian society, the Indian market wasn't so big. It was essentially agrarian. We, at the time of independence, we didn't have much of manufacture. And we also followed what is known as the public sector model, which is Jawaharlal Nehru. Socialism, directive principles of the state policy that tells you that the state shall ensure that the means of production are not monopolized into a few hands. So Jawaharlal Nehru, in his wisdom as an economic planner, decided that the public sector is going to play a big role in the industrialization of the country. Now, after about 40 years, under the leadership of Mr. P.V. Narasimha Rao, Dr. Manmohan Singh, Atal Bihari Vajpayee, now Mr. Narendra Modi, all the prime ministers, irrespective of the party affiliations, have convinced themselves that the public sector model is not the best model for the development of India. And now the government is busy involved in divesting the investments that they have made. This is one of the important methods of reducing the current account deficit of India. I'm not getting into economics, but we have to recognize that when we are going to talk about industrialization, industrial monopoly, prevention of monopoly abuse, facilitation of free competition, you can't divorce economic factors from the area of your discussion. Now, let's cut the long story short. We are convinced today that public sector model is not the best model. So what happens? You have to allow your industries to grow. When they grow, they may acquire what is known as a dominant marketing position. Okay, market dominance. And the purpose of competition law is to ensure that if there is going to have an adverse effect, if a commercial practice is going to have an appreciably adverse effect on the relevant market. This is the expression used under the competition law. Something which is going to have an adverse effect, appreciably adverse effect in the relevant market that will reduce competition. Competition Commission will get into the picture to regulate the situation. So therefore, Competition Commission thought that since these players are monopoly players, Ericsson was undoubtedly one, Monsanto is yet another company which is having a very dominant presence, not only in India, but also all over the world. That's the same in respect of Ericsson also. These two companies license their industrial monopoly. Whether there can be an abuse. Now, Competition Commission said that we are a specialized body created by Union of India to look into the issues of competition, and we have skilled, trained human resources to determine, number one, what is a market? Number two, what is the relevant market? Number three, effect on market. Number four, adverse effect on market. Number five, appreciably adverse. Each of the criteria require a lot of careful determination. Now, in view of this, we are the best people to consider the legality of these practices. The Delhi High Court in the division bench has held no. Both are specialized legislation. Patent Act is a self-contained legislation. The Patent Act in Chapter 16 provides elaborate provisions of compulsory licensing, patent abuse, revocation of patent, notification of patents in public interest, and compulsory licenses for export. And therefore, if there is going to be an abuse of patent monopoly, that will have to be worked out under the Indian Patent Act. Competition Commission is not competent to exercise jurisdiction. Actually, I don't agree with the judgment. Never mind, and it's only an opinion. And why I don't agree? I think it will be a more accurate topic in a special course on competition law, which I intend definitely putting up. But for a pharma course, it is a relevant precedent. Whether this precedent will automatically apply to pharma patents? Well, it should, because the court in its wisdom has decided to club a telecommunication patent along with the biotechnology seed patent and give a judgment, a combined judgment has been given. Whether it will apply to, because I am conscious of the fact, patents in one sector of industry in terms of effect, profitability, cost benefit, longevity are totally different from other sectors. Okay. And each one is a constitution by itself actually. I mean, it's so much complicated actually. So there, but at the same time, I must say this is the binding applicable precedent unless it is reconsidered by the Supreme Court. Most of it I will consider in a later lectures, probably in a different course. But this is the general introduction I wanted you to have about patent licensing, judicial review of patent licensing before we go into pharma related patents. Thank you.